Step 4. Default. We talked a little in the beginning about a default. In the event that you think your opposing party is not going to respond either because they are out of the state or they are, MIA or they agree with everything, you can consider filing for a default. If you do that, if you know that you want to file for a default, and this can be a strategic move that you and your spouse or your ex make, then what you needed to do is draft a very specific petition that also includes your parenting plan that says, here's exactly what I want, you serve the other party, you pay your filing fee. If the other party agrees, then you can go forward with the default and that opposing party avoids paying a $268 response fee monthly. So it's an absolutely valid strategy to people who agree, because there's no way in Arizona for you to get an uncontested divorce. Someone must file a petition, same thing with establishing paternity legal decision-making, which is legal custody. And let's just talk for a minute. We'll pause on default and talk for a minute about these terms. Legal decision-making is legal custody. It's who makes the major decisions for the child, where they go to school, whether or not they get on medication, or get a surgery that might not be an emergency surgery, that sort of thing, their religion and personal care decisions. Most of the time, the courts prefer joint legal decision-making, which requires both parents to talk and make decisions together. That's not always the case, and there could be very good reasons why there should not be an award of joint legal decision-making. So do not think that you have TOSC for joint legal decision-making. I'm seeing right now a lot of pressure being put on people. They're being told to don't even bother asking for sole legal decision-making. And that's a mistake. You really need to look at your facts and apply the law and then determine what's going to be most appropriate for you. Legal decision-making is separate from parenting time, and Arizona has done away with the term visitation. No parent is given visitation. Each parent is given parenting time. And we have statutes in place that require very specific rules for the parenting plan that must be in place. It's not okay for the two of you to come up with a parenting plan that is, so and so will be granted liberal or reasonable parenting time. The courts and the statutes require that you have a specific parenting plan in place that deals with vacations, holidays, transportation, and specific days and times for each parent to have parenting time. With that being said, there is also a preference for maximizing parenting time with both parents, when you have good parents, when you have safe parents. If that's not the case, then you do not need to feel pressured into entering into an equal parenting time arrangement. If that's not what's best for your children, that's not right in your circumstances. We really do have to look at that case-by-case basis. With that little aside, we'll go back to the default. If you have served the opposing party and they have not responded, they have 20 days to respond in Arizona, 30 days to respond if they are out of Arizona, then you can file an application and affidavit for default. They get 10 more days to respond and you serve them with that application and affidavit of default. At that point you can request either a hearing, if you have children, and you would go before the judge for a default hearing, or you can submit paperwork, a decree for the judge to sign, if there are no children involved. Be aware, one more piece of time frame to keep in mind is that there's a 60-day waiting period for divorce, so you can't file really your application and notice of default or submit your decree to get it signed before that 60 days. That's something to keep in mind when we are also considering the 20 days plus the 10 days. We've got to factor in those 60 days as well. A hearing is usually required when there are children involved. So what that looks like is you call the court, you make an appointment. You and a bunch of other people show up on the day of your default hearing, you wait in line, you go before the judge. The judge will compare the petition and the decree, so you have to bring a decree with what you want to have happen. The decree must match what you've asked for in the petition, because the person who was served, the respondent who did not respond, deserves to know what it is that they have waived their rights to by failing to respond. We cannot have a very vague petition that you then go get a default judgment on.